Welcome, everyone, and thank you for joining us for today's webinar, Come and Get It, a legal update on discipline and mental health issues for special education leaders. I'm Stephanie Taylor, Manager of Behavioral Mental Health and School Psychology Services at Presence Learning. Tens of thousands of educators, SLPs, OTs, and mental health professionals have tuned into our Sped Ahead webinars, and discipline, behavior, and mental health remain some of our hottest and most requested topics. Be sure to check out our library of on-demand webinars at presencelearning.com to learn from experts like Dr. Randy Sprick, Dr. Ross Green, Dr. Ed Dunkelblau, Dr. Dan Crimmins, and more. Today, we segue from understanding and managing student behavior and school climate into the legal realm. What legal considerations do special education leaders, district administrators, and related service professionals need to keep ever present in their minds? I came to Presence Learning after being a special education teacher, school psychologist, and special education director in public schools. As a way of introducing this timely topic, let me say that mental health and discipline are close to my heart and were a constant source of anxiety and frustration for school teams. In the early years of my career, I was constantly surprised by the pervasiveness of mental health needs across the pre-K-12 spectrum. I was surprised not only at the level of need regardless of age, but also at the types of needs. Things that I thought would be contained to older students like language, violence, pornography, school refusal, anxiety, depression, and sheer defiance were equally typical in younger students. And things I thought were more likely to be found in the younger ages like encopresis and enuresis, crying, tantrums, were just as prevalent in the 6 to 12. That steep learning curve taught me that I couldn't assume anything, and also that I really needed to rely on the amazing teachers, administrators, and related service providers I worked with, and they became my fellow sleuths, and we would try to navigate the world of educationally related behavioral and mental health services. It seemed that each of us had a different piece of the puzzle. We came at the issue from different eyes, with different concerns, and with different knowledge levels. We all wanted so much to do what was right for the student, for that student, for all the students, and the school, while we considered all the moving parts. We sat and debated the meaning of educationally relevant, satisfactory relationships, and social maladjustment, all while trying to figure out what we really had to offer the student and whether or not it would be enough. And I know we are not alone in that, for that has been the one constant regardless of which position I have been in, is what do they need, what do we offer, and are those things equal? And that question has guided many of our decisions, especially when the answer was no, because that is when the real problem solving starts. And the need for actual guidance, like what is being offered in today's webinar, became a life preserver. And we haven't even talked about discipline yet. Discipline adds an additional layer. When working with students with disabilities, determining the extent to which their disability was impacting their behavior proved to often be as complicated and intricate as developing the entire individualized education plan. Those same amazing school teams often struggled to apply a discipline system to students in special education that was created for students without special needs. And we made process checklists and decision trees and went through manifestation determinations, but it seemed like every circumstance was somehow extenuating or special to where we struggled to apply unilateral rules. This very real and emotionally draining struggle of balancing the needs of students and the rules necessary for the school environment is one of the reasons I'm sincerely pleased to have Julie Weatherly here with us today. Even though I had great school teams, sometimes I felt like it was all on my shoulders and I needed help. Resources that helped keep things clear, helped me focus on the right factors, and guided me through the maze of legality and appropriateness gave me the support I needed when I was the most worried. And I hope that is what everyone leaves here with today, a way to look at the maze of mental health and discipline and see the end so you can work your way backward. With that, I give you Julie Weatherly. Julie is the founder of RISE, which provides legal services and consultation to public school districts and educational agencies on special education law. She is a widely noted speaker for conferences and workshops and has appeared on 60 Minutes with Leslie Stahl for her expertise. Julie has also been recognized by the National CASE organization for her outstanding service in the field. Julie, over to you.
Thank you, Stephanie, for your kind introduction. Very kind indeed. And a warm welcome to our audience out there. I really appreciate the opportunity to be invited back to provide my perspective on mental health and discipline, which are obviously two very important legal issues that special educators are facing every single day. Thanks again to Presence Learning for sponsoring this webinar, and as always, its continued commitment to great online professional development. Now, I want to be sure that everyone out there who's listening in knows that there is a lot more to these hot topics than I could possibly cover during this webinar. So I want everyone to be sure to study the information in the resource handout provided to you, because I'll be referring to that material throughout my entire presentation today. Now, let's get to the next section of our webinar, and that's part 2. We're going to take a look at special education law as it relates to student mental health issues, and I'll cite a few cases as examples as I'm going through. We're going to start talking about an exploding issue, probably one that has surfaced as the most important topic in my law firm. In our firm, we are seeing a lot of issues that relate to students with mental health concerns. It's almost staggering to me. And there is a difference between mental health issues and mental illness, of course, but we really need to consider both when we are looking at our school's obligations to those students. And it is staggering, the number of cases that we're getting. Just in our firm beginning this year, in talking to my law partners, we noticed and had an actual conversation about how astounded we were that it appeared that the calls we were getting from our clients had probably quadrupled by the beginning, just the first month of the school year. People calling us in somewhat of a panic with respect to their options related to a student with significant mental health issues. Usually severe behavior problems, but the notion is not we want to get them out. The notion is, what do we do? What are we going to do? I mean, really violent, aggressive behaviors that have been described to us. And while I have had these kinds of cases over the years, I've not seen it in such numbers. And I am a school attorney, so I'm always looking to what is educationally appropriate for students with mental health problems. But many of the students need more than just education. They need mental health treatment. And what I'm worried about is that the IDEA is the only statute standing that gives some entitlement to rights and an entitlement to challenge the program a student is getting, such that schools are becoming more and more responsible for mental health issues. And some of the other agencies out there that are better equipped and are designed, even under state law, to deal with those issues aren't stepping to the plate. And if Congress really wants to get the job done with respect to these kinds of issues, there will be more accountability and more teeth in some of those laws. Right now, they're just grant programs, and the IDEA actually contemplates specifically the mandate that states have cooperative agreements in place that make it very clear what agencies are responsible for, and that the education agencies are responsible for education, the mental health agencies are responsible for mental health, and so forth and so on. And there are supposed to be good, solid cooperative agreements in place that are enforceable. The problem is, in many states, that's not the case. Or they may be enforceable up to the point where that other agency runs out of money and says we can't do that for that child anymore. And there is supposed to be a mechanism available in all of those cooperative agreements for school districts to be able to go to the agency and say, you haven't met your obligation, therefore you owe us reimbursement for this, that, or the other, or whatever it might be. Unfortunately, though, they're really not enforceable. There's no mechanism for a school district to actually enforce that unless there are specific enforcement contractual provisions there, which I find lacking. So if Congress really wants to do anything with respect to mental health, they need to look at some sort of law that makes agencies, all of them, accountable for the services that they are required to provide to students. Now let's talk about the laws that apply to educational agencies and what we might be required to do. My materials obviously are focused on the presumption that students with mental health issues are more than likely going to be considered students with disabilities, but I do want to make sure you understand that I don't necessarily believe that to be 100% the case. There are going to be some students with mental health issues that need to be addressed through the problem-solving team, child study team, whatever process, whatever you refer to that in your state. And there are a lot of articles out there with respect to students who have been exposed to trauma and some recommendations for good instructional strategies for those kinds of kids. So I do acknowledge that not every student who has a mental health concern is automatically a student with a disability. First of all, your initial question is whether or not a child with a mental health issue is a student with a disability. So in talking about the relevant federal laws, obviously we start with the IDEA, the Individuals with Disabilities Education Act. Many teachers think that IDEA stands for I Do Enough Already, but it is that good old Public Law 94-142, and that's our primary statute. But another law that has been gaining in popularity, and in fact I will say that probably half of the work that I do today relates to students and their rights and our responsibilities to them under Section 504. And that is short for Section 504, the Rehabilitation Act of 1973. And I can't fail to mention the Americans with Disabilities Act, or the ADA. That is the sister statute to Section 504. So you're going to see some references to the Americans with Disabilities Act in my materials as well. But when we have school teams, we generally think about our IEP teams and our 504 teams. And those are going to be the teams that will be addressing what responsibilities we have to students who have mental health issues. So my discussions really only focus on federal law. States can add, and in many cases involving obligations to students with mental health issues, states have added, and more states are adding responsibilities as it relates to mental health issues. So you also need to be very familiar with what your state requires of schools as well. This is just a discussion with respect to the federal scheme. So let's go ahead and start our discussion in terms of the IDEA and the obligations that it might impose as it relates to students who have mental health concerns. And of course, that's the most comprehensive law. That's the one that has all of the procedural safeguards and protections in it. It's much more prescriptive than Section 504 might be. And of course, when we're talking about children with significant mental health problems, generally that child is going to be a child who is a child with a disability under the IDEA. The ones that concern us the most in terms of our obligations are more than likely going to be a child with a disability under the IDEA. So we have a definition section under the IDEA. There are the federal categories that I have listed in terms of those conditions that the federal law recognizes as disabilities for purposes of what we might call eligibility under the IDEA. Starting with these conditions, and of course, states can add to this, and some states have in the past, things like other conditions that a particular state decides to add to the mix here. But when they add to the mix, they're not necessarily going to be able to collect Part B money to serve those children, because these are the conditions covered under federal law. The statute itself, except for SLD, doesn't provide any guidance with respect to specific definitions, but the IDEA regulations that are very prescriptive provide much of the additional information that we get as it relates to the definition of a child with a disability. And there are a couple of categories that even the regulations have added, such as deaf, blindness, multiple disabilities, to the statutory list that's there. One point I need to make today is that many students who meet the definition of a child with a disability might also have a diagnosis under the DSM-5. And that's the Diagnostic Statistical Manual 5, number 5. We get a lot in the schools of children who have these private diagnoses of medical conditions. But that does not, in and of itself, tell us anything with respect to why or whether or not a child is a child with a disability under the IDEA. Students with mental health concerns typically have some sort of DSM-5 diagnosis. But again, it does not equate to eligibility as a child with a disability under the IDEA. So we have to, of course, collect all of the data that is required by a particular state to meet the definition. And again, many students who have mental issues, especially significant mental health issues, are going to probably more than likely qualify under IDEA. The condition that we think of or that's most associated with mental health concerns is the condition of what we used to call serious emotional disturbance, and that's how the law refers to it, but then more specifically took the word serious out and just plain old emotional disturbance. Looking at this definition of emotional disturbance is defined as a condition exhibiting one or more, so it only takes one of the following or more characteristics over a long period of time. That's important. A lot of times students have mental health issues that are in response to some sort of crisis, and so it's not really a long period of time, so that's important to keep in mind. And to a marked degree, so that's another piece that needs to be emphasized when teams are sitting down and looking at their data, that adversely affects a child's educational performance, and it's one or more of the following characteristics: an inability to learn that can't be explained by intellectual, sensory, or health factors, an inability to build or maintain satisfactory interpersonal relationships with peers and teachers. And of course, these are, take a look at some of these words. Satisfactory relationships. It could be satisfactory to the student and not to everybody else. I mean, those are really interesting words that they use. Inappropriate types of behavior or feelings under normal circumstances. In this day and time, what are normal circumstances? Can anybody tell me? I'm not sure what's normal anymore. But it could be, what it's normal circumstances for the child, or is it normal circumstances? Is there a major matter of opinion and perspective with some of these particular factors to look into? A general pervasive mood of unhappiness or depression, or, because remember, it's or, a tendency to develop physical symptoms or fears associated with personal or school problems. Now, the interesting part that has led to a bit of litigation is the note here: the term includes schizophrenia, but does not apply to children who are socially maladjusted unless it is determined they also have emotional disturbance. So can anybody tell me how you do that? Especially without a definition of social maladjustment. There is no definition of social maladjustment there. And there's been some commentary with respect to that issue for many, many years. But olden times tell me that there were certain members of Congress who said, no, we're not including those kids who are socially maladjusted. And we know what we mean when we say that. We're just not going to tell you. So they give us no definition of what social maladjustment might mean. There are very many definitions, and even some courts have adopted some definitions of social maladjustment. But the word that comes up the most to me to distinguish social maladjustment versus emotional disturbance is the word purposive. Now, I always use the word purposeful, but purposive is one that I have seen in the writings that I've looked at. And legally, looking at court cases, there have been some courts that are willing to make that distinction. But I can tell you that if a school district wishes to go down that road, they need to have good expert witnesses that are well-versed in the difference between an emotional disability and whatever this social maladjustment is. Okay? Now remember, we're only talking right now about IDEA, not 504, so hold on to that thought for a second. So although emotional disabilities might come to our minds most frequently when we're talking about the really difficult students who have mental health issues, I can't say that they're all going to fall under the emotional disturbance category. It could be that a student with mental health issues is autistic or other health impaired or learning disabled. They could fit into any of those categories. So the label is just the way we find the child eligible, and we open up that door to everything that is available to provide that student with free, appropriate public education. So let's say a student is found eligible as a child with a disability under the IDEA. What action or services are we required to provide? Well, obviously, I'm going to start with the definition of special education. Specially designed instruction at no cost to parents, that's the free part, to meet the unique needs of a child with a disability. And it includes instruction conducted in the classroom, instruction in the home, instruction in hospitals and institutions, and in other settings. This piece, to me, tells me that we're talking education being instruction, instructional in nature. And if you think about it, if a child needs to be treated in an institution or what have you, then certainly they're entitled to FAPE there. And that would be the educational responsibility of schools. But I can tell you the arguments have gone well beyond that in terms of what constitutes instruction. When talking about eligibility, specially designed instruction is defined as adapting as appropriate to the needs of an eligible child, the content, methodology, or delivery of instruction. And the purpose of that is to address the unique needs of the child that result from the child's disability and to ensure access of the child to the general curriculum so that the child can meet the educational standards of the applicable local education agency or state educational agency. And so to me, that's really important when we're talking about eligibility questions. Because if you have a student with mental health concerns who even technically meets the definition of emotional disturbance, but actually does not need specially designed instruction because is absolutely able to access the general curriculum and is meeting educational standards, then perhaps they are not a child with a disability because they don't have that need for special education. So I think it's always, if you've got an eligibility question in front of you, it's always very, very important to look at the need for special ed services as part of the analysis, not just whether the student has a condition and meets the eligibility criteria based on evaluative data, but also needs that special ed service. Also, too, under the law, we have related services. Related services under the IDEA are different from related services, let's say, under 504, and I'm going to get to that in a little while. But specifically defined under the IDEA overall, these are related services that are required for the student or to assist the student in benefiting from their special ed services. So they're technically supposed to be related services, related to the child's disability and related to special education services. Sky's the limit as it relates to what could be a related service necessary for a student to benefit from special education. Regarding students with mental health issues, I think there are some important related services to consider, including psychological services, social work services, even school nursing services. Counseling services are also potential related services. The regulations also add early identification and assessment of disabilities in children. And I will tell you that I think with respect to students with mental health issues, the sooner the better. And I actually like the fact that early identification is emphasized. The regulations also added school health services and notably parent counseling and training. When I'm talking with a client and I say, well, you know, parent counseling and training could be a related service, they're like, where's that? I'm like, I promise you, it is there in the regulations. This was specifically added. Now, that doesn't mean that if mom and dad are having domestic issues or marital concerns that the school district needs to fund their counseling. It really is defined more in the nature of assisting a family to deal with a disability to help and assist the child to benefit from his or her special education program. And then the vehicle for providing these services. The services are delivered via the IEP, and you all are very familiar with that vehicle. Then we have to turn to Section 504. So let's pretend that we have an issue with a student and we decide the child is socially maladjusted and has a lot of mental health concerns, but basically is not necessarily emotionally disturbed. Might they fall under 504 or the sister statute, the Americans with Disabilities Act? But really our focus in schools when we're talking about provision of services and our obligations, we focus primarily, as I said earlier, on 504. Might they be eligible, so to speak, under 504? There is an old OCR, Office for Civil Rights, interpretive letter where they clearly said that while social maladjustment might not be a disability under the IDEA, it could very likely be one under Section 504. So after all of that work, all that you went through, you also need to consider whether or not the child could be a child with a disability under Section 504. And as I said, we are seeing 504 expanding beyond the point that I ever thought it would. Now, one thing I want to make clear, though, I don't use the term eligibility when I'm talking about 504. I just used it, but when I'm working with school folks, I usually talk about making a disability determination, because eligibility in the land of IDEA means you're eligible for something, you're eligible for an IEP, and that's not necessarily the case under 504. And I'll explain that a little bit later when we get to the actual disability determination discussion. So let's take a look at definitions. The definition of an individual with a disability, when I'm training on this, and I can tell you this takes at least a full day to make sure that people really truly understand what 504 is, what it is not, who it applies to, who it doesn't, all of those kinds of things, because there's a lot of confusion out there. But suffice it to say that the Section 504 ADA definition of an individual with a disability is extremely expansive, to the point where I could assure you that 4 out of 7 days a week, you have a disability under Section 504 of the Americans with Disabilities. I know I do. I am almost certain everybody does because of the expansive nature of this particular definition. Individual with a disability is someone who has a physical or mental impairment that substantially limits a major life activity. And that is generally what every, quote, 504 team making a disability determination is going to be doing. And that is looking at all relevant data and asking and answering whether this child has a physical or mental impairment that substantially limits a major life activity. So that's the heart of, when we're talking about a child with mental health issues, and let's say otherwise not found to be a child with a disability under IDEA in terms of our responsibilities to that child, looking at 504, does this child have a physical or mental impairment that substantially limits a major life activity? But we are looking to teams to determine whether there's a physical or mental impairment that substantially limits a major life activity. And if you go into the definition, which we need, of a physical or mental impairment, you can see already how expansive this old definition is. This comes from the 70s. It's been updated by the ADA since then. But when you look at it, it starts with the word any physiological disorder or condition. Well, the word, when something starts with the word any, we're talking it's big. This was never meant to be all-inclusive. Any physiological disorder or condition, cosmetic disfigurement, anatomical loss affecting one of the following bodily systems, and they name a lot of bodily functions there and a lot of bodily systems, but not all of them because the ADA expanded that too, or any mental or psychological disorder, such as mental retardation, which of course we don't use that terminology anymore, so they need to clean that up. Organic brain syndrome. Anybody know what that is? Some experts that I work with have told me that that's what we currently refer to as ADHD today. I don't know if that's true. I wasn't around then. Don't practice in that area, but that's what I've been told. Emotional or mental illness and specific learning disabilities. To have a disability under 504, there has to be a finding that this physical or mental impairment substantially limits a major life activity. So many people walk around with a physical or mental impairment, but it doesn't substantially limit our ability to do anything. So there's further analysis in this whole looking at whether a disability exists under 504 and looking to the definition of major life activities under 504. Well, in the 70s, that include functions such as caring for yourself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, and working. Okay? We used to focus, in the good old days, we focused only on the major life activity of learning until after 2008 when the ADA amendments came out and made it clear that, oh no, you don't just look at learning in the school environment, because we are responsible for making sure that all children with disabilities are not discriminated against, not those that just have disabilities that impact on their learning. And I'd always said that, but some school districts had gotten to the point of only looking at learning when making the analysis of whether or not a child had a disability under Section 504. So since that time, OCR has made it very clear that you don't only look at the major life activity of learning. You'll note in 2008 and then subsequently in 2016 with the ADA Title II regulations, there are now some presumptive physical or mental impairments that include emotional illness and ADHD. And technically, ADHD is viewed as a mental disorder. It's in the Diagnostic and Statistical Manual of Mental Disorders. That's what it is. Then they also expanded, as part of the new ADA Title II regulations and the expansion by the 2008 ADA amendments, expanded the definition of major life activities. And they added sitting, reaching, writing, and interacting with others. There are a lot of major life activities that are not included, but adding interacting with others, I think, is very significant as it relates to students with mental health issues. Noticeably absent from 504 is a definition of substantially limits. And that's the piece that I find 504 teams really grappling with when they're trying to figure out, is this a child with a disability to whom we have obligations under Section 504? This is where they get caught. And I've even had clients that created certain scales in terms of how much it impacted on the child to determine whether it's really just substantial or is it just a little bit. But now the U.S. Department of Education's Office for Civil Rights and the Department of Justice have said, don't spend a lot of time on that. You need to err on the side of expansive coverage. Don't get bogged down into what substantially limits is. And that sounds real good when you're talking about disability discrimination. But when you're talking about putting a 504 educational plan in place, it becomes a little bit more complicated. But it is to be construed very expansively, and the ADA Title II regs, again, effective in October, said you just really shouldn't engage in any kind of extensive analysis. Err on the side of finding a disability. Now, only one major life activity needs to be substantially limited in order for a student to be considered disabled under 504. A student diagnosed with bipolar disorder would not have to demonstrate a substantial limitation in the ability to learn to be considered disabled under Section 504. So they still could be substantially limited in, let's say, the ability to interact with others, therefore they're going to be disabled. So that's an important piece because I do find mistakenly some school teams focusing on that learning piece when socialization, other kinds of issues may be just as important, especially when they've added interacting with others to the major life activity definition. One other point that I make here, just a reminder hopefully for most of you, and that is that Section 504 teams, when making the disability determination, are to consider the student and whether a physical or mental impairment that substantially limits a major life activity exists, absent the ameliorative effects of mitigating measures. The positive effects, that's so much easier. The positive effects of any mitigating measures that they might be utilizing, such as medication. Obviously, a lot of students who have mental health issues, and I will say in some cases, very unfortunately, are medicated. But if indeed the medication mitigates the effects of that physical or mental impairment such that it doesn't substantially limit, you have to consider the question as if the child were not on medication. And sometimes that's very, very hard to do. And the Office for Civil Rights, most recently, in the ADHD Resource Guide, again, if you are responsible for 504 or involved in that at your school, you need to get a hold of the Dear Colleague letter and ADHD Resource Guide that was issued by the U.S. Department of Education's Office for Civil Rights in July of 2016. It's very comprehensive, and it will provide a lot of guidance to your teams with respect to what OCR views to be a disability and how to make this decision. So if the child's not a child with a disability under IDEA, is it possible, more than likely probable, that the child's going to be covered under Section 504? But what does that mean for that particular student if they are a child with a disability or an individual with a disability under Section 504? So let's talk about action and services that are actually required. So assuming, and even we're going to err on the side of deciding the child has a disability because of this expansive definition, what does that mean in terms of the obligations? What's the school required to do then for that child who has mental health concerns that amount to ultimately a disability under Section 504? And I call this 504 FAPE. Okay? 504 FAPE is defined as services that are regular services or special education. Now, where it says or special education, that propels us into the land of IDEA to me. And their special services are provided through IDEA. But regular services, in OCR's eyes, also include special services that we might call related services in the land of IDEA. And that's how they define special services if you're just talking about a 504 disabled child who is not otherwise a child with a disability under the IDEA. And these are supposed to be services that the 504 team determines are necessary because they are needed to meet the individual educational needs of children with disabilities as adequately as the needs of non-disabled children are met. Well, what in the world does that mean? Well, the needs need to be met of the disabled children as adequately as the needs of non-disabled children. But technically, couldn't that mean that if you provided really cruddy services for non-disabled, you could provide the same cruddy services for disabled children? I mean, technically, yes. But this is a question that a 504 team is going to ask for a student with mental health issues that they've determined has a disability. Does this child need anything from us to have his educational needs met as adequately as those of non-disabled children? And that's part two of what a 504 team does. And it could be that the answer is no, this child has a disability but doesn't need services, or this child has a disability and does need these services. Just because a child has a disability under 504 doesn't necessarily mean they need services or 504 FAPE. That is the second determination that 504 teams will make. If it is decided that a child does need services, they're going to be documented in a 504 plan. Now, it's interesting, just for those of you and some of you who are responsible for 504 know this, but I get in arguments sometimes with folks. 504 requires us to write up a plan. Nowhere does it require a plan, but it has become best practice across the country for school districts to create something called a Section 504 accommodation plan. And it's interesting, they even go further to say, we also think the team that develops this plan should be comprised of a team that's similar to what an IEP team might look like, and they even suggest that you have to have an LEA representative at 504 meetings. But they acknowledge the law doesn't require it. But I'm here to tell you that you might as well do it because you need to document what you're doing. So what might those services look like for a child with mental health issues? Well, more than likely, they're going to be related services. So it may be support services in the form of some counseling, even some counselor from the mental health agency, whatever it might be, those kinds of related services, social skills training. Also, too, though, there's a second prong of 504, and that's making sure that those students, even those that we decide don't need a plan, are not discriminated against. For instance, a student with mental health issues who needs to leave school early to go visit with a psychiatrist for private counseling. We should provide the accommodation of an excused absence, an accommodation of allowing the student to make up any work the student might miss because of this. Also, too, we can't take action that would be discriminatory. So the principal says, all children that have mental health problems are not going on to field trips anymore. They are just too much trouble, too high maintenance. That would be discrimination solely on the basis of disability. All right, let's talk about some specific issues then. Let's talk first about that child find duty. Now that we know that it's more than likely, not in every case, please don't quote Julie Weatherly saying every child who has a mental health concern is automatically disabled. But one thing we are obligated to do is ensure that the child find duty, both under IDEA and Section 504, is met, that we fulfill that child find duty. And this is what the law refers to it as the duty on the part of schools to ensure that we locate, evaluate, and identify students who might be disabled and in need of special services. With this, we have seen a problem with respect to RTI. We have to make sure that the implementation of those strategies and interventions via an RTI process are not used as a barrier to conducting timely evaluations to determine whether a disability exists, because that can run afoul of the child find requirement. If we suspect or have reason to believe that a child is a child with a disability or might be and in need of special services, either under IDEA or 504, then there is an obligation under the child find duty to refer that student for an evaluation. You really need to take a look at whether or not the child is already responding to certain interventions that the problem-solving team has already decided. If the data is looking good and those are successful, then there is no reason to believe or reason to suspect. So we really need to take a look at all the data. I will tell you, as I say here, in my experience, I think that the duty to refer a child for an evaluation is probably going to be triggered under 504 before it is under the IDEA, especially for students who don't have really any academic performance issues, because OCR doesn't limit their analysis to those students who are struggling necessarily academically, and they don't really look necessarily to just instruction. So what could be reason to suspect or reason to believe sufficient to trigger the child find duty? I'm going to highlight a few of these. I've actually created this list. I call it a referral red flags list. And I even categorize them: academic referral red flags, emotional behavioral referral red flags, information that comes from the outside could constitute a referral red flag, information from the inside, and then a parent request for an evaluation, which is one of those real red flags waving in the wind. Okay, so starting with academic concerns, of course, dealing with grades. I will say that it's not a wait to fail model. Child find is not a wait to fail. And I do from time to time hear that, well, why would we refer her for an evaluation? She's not failing. And that concerns me. So clearly the courts don't expect that it goes to straight failure. It's just difficulty or noticeably declining grades. A child is retained. Again, not every child retained in their educational history needs to be evaluated. But when you see a number of these, it starts to concern us as to whether or not the child find duty to refer for an evaluation has been triggered. Poor or noticeably declining grades, progress on standardized assessments also included. For IDEA purposes, many times in these child find cases, a referral red flag is the child has a 504 plan, and it's not been effective. So that might be a trigger for an IDEA evaluation. Then you have similar ones in the category of emotional and behavioral concerns, signs of depression, other emotional issues, withdrawal, inattention. Disciplinary referrals come to mind most frequently. Some principals will tell me from time to time, well, she doesn't have behavioral issues, she's never here. Well, truancy, I can tell you, is considered by courts to be one of those behavioral referral red flags. So we get outside information. This is where it gets a little sticky. So I'm not saying that every time the parent comes in with a diagnosis of some sort of mental health concern that we automatically need to refer for an evaluation. But I can tell you that many times we get reports that have diagnoses in them and all of those kinds of things, and unfortunately I'm finding more often than I would prefer private providers prescribing 504 plans, or prescribing IEPs, prescribing an evaluation, all of those kinds of things. Again, it's one piece of information for a teen to consider. But also you might find out that the child at one time has been hospitalized, particularly for mental health reasons, chronic health issues, those kinds of things ought to trigger some concern. And then you take a look at all the other data that you have available. Again, I'm not saying that every child with a DSM-5 diagnosis needs to be referred for an evaluation, but I can tell you that courts consider it as a referral red flag in certain circumstances if there are a lot of other things going on with that particular child. Medication might be one of them. Many times we know children are seeing outside counselors, outside therapists. We ought to kind of be on alert to determine whether or not, are we seeing other issues going on with this child that are affecting what's going on here at school that would trigger the suspicion that the child might have a disability, and so forth and so on. Then we have our own internal conversations. I see a lot of emails between school staff saying things like, when is he going to be referred for an evaluation? This kid is the sickest kid I've ever seen, et cetera, et cetera. Those can be used against us in a child find case, I guarantee you. And then lastly, the parent requests an evaluation, but I want to make it very clear that we don't necessarily wait for parents to request an evaluation. There's a number of cases that are case studies, but one of the, I would say, most famous child find cases, the Compton Unified, if there were a dictionary and it was defining the term child find violation, it would have a picture of this case there. Because it's kind of an interesting case where the court was addressing a school district's defense. The school district took the position that, well, yeah, she had a lot of issues, but the parent never requested an evaluation. So she can't sue us for anything because we didn't do anything, which I find kind of interesting. As a lawyer, that kind of makes sense to me. But what the court said was, no. The failure to act is not necessarily in response to something. Parent doesn't have to ask. The child find duty is an affirmative duty. We are supposed to be on the lookout for those reasons to believe or reasons to suspect that would trigger the child find requirement to refer the child for an evaluation. So just in this case alone, this is why I find this one to be a great case study. The failing 10th grade student, so failing, there's a referral red flag number one. Referred by the school to a mental health counselor. There's referral red flag number two. That counselor ultimately recommended an evaluation for special education. There's number three. Her teachers indicated that her work, when she did it, was gibberish and incomprehensible. There's number four. She played with dolls in class. She's 10th grade. There's number five. Urinating on herself. There's number six. Okay, so was that sufficient at that point to have referred this young lady for an evaluation, even though the parent didn't ask for it? And the court said it clearly was. I will say also the Jackson case, I have heard that referred to as a case that stands for the proposition that every child who's receiving RTI interventions is automatically a child with a disability. Be still my heart if that's the case, right? I don't read this case to say that at all. What it was a discipline case where they expelled the young lady who was clearly in need of an evaluation. So it's a child find case. The manifestation determination was reversed and the expulsion was reversed because she clearly had signs that she should be evaluated and considered a child with a disability, but was treated as a non-disabled child. She had received RTI interventions, but it was for 2 years, and the data reflected very limited gains. And the court said that, in and of itself, is a referral red flag. So for child find reasons, the disciplinary action of the school district was overruled. All right, let's talk about some other issues that become an issue. I will say probably the biggest question that I have for schools, and the thing we grapple with the most, is when do these related services actually become treatment for a child? And as my clients, admirably so, are gaining more cooperation and coordination with mental health agencies that are local, bringing mental health services to the schools, while I'm very, very happy to see that, I wonder what happens if all of a sudden the mental health people say, we don't have any more money, we'll see you later. What's going to happen then? Did it just become a related service? And that's why I'm saying that schools can't run out of money. Do we get to say we run out? Oh, we can't do FAPE anymore because we don't have the staff. No, we don't get to do that. That's what I'm saying. That's what the problem is the mandate's not there. It is limited by virtue of the resources that are, by grants and that kind of thing. And certain communities have things better going on than others do. Where this is more of a concern is with residential placement. Because, again, schools are the only ones that have a law out there that obligates it. So is the argument then that the school, as part of FAPE, is responsible for residential? Well, there are tons of cases on this issue. One thing that's real important here, if you're dealing with a residential placement issue, you need to become very familiar with, number one, your school attorney, and number two, the applicable law in your jurisdiction. Because to me, there seems to be a bit of a split with respect to how courts are analyzing the obligation to students with significant mental health issues in the form of residential placement. The one that I want to point you to is the Jefferson County School District case out of the 10th Circuit, which did a very good job of summarizing where all the circuits are, noting that the 5th and the 7th Circuit have a primary purpose test. What is the primary orientation of that residential placement function? Is it to treat mental health illnesses or health issues, medical issues, or is the primary function of that school or residential treatment facility oriented toward education? So that makes a difference because a lot of these facilities, you will look on their webpage or whatever, and they're all about mental health treatment or drug treatment or what have you, and education's just a little part of that. And ultimately, if a court rules that the school system's responsible for residential because it's necessary to educate the child, the parent doesn't care. As long as they get it paid for, they don't care if mental health doesn't contribute to it or whatever. And school districts don't have standing to sue to even enforce cooperative agreements and those kinds of arrangements. But this is a really good case to analyze all the circuits and all the tests they use. One of the very first residential placement cases, the North case, said trying to distinguish between educational and medical or social and emotional needs and reasons why a child's placed residentially can become a Solomon-like task. And so some courts aren't willing to engage in that Solomon-like task and may very likely order the school system to pay for a very expensive residential placement. And unless schools are inundated with too much money, this is a big problem. I don't think schools are the proper place when we're talking about mental health treatment issues. I just don't think educators are even trained necessarily to do those kinds of things. Another disturbing case, Sacramento City Unified School District. The court here said, I'm not really sure this child needs these mental health services in order to be educated, but since the school included the student's social and emotional development as part of the IEP and included mental health services to address that, and they weren't sufficient, this particular school district's taken that on and is therefore responsible for residential. Well, aren't we supposed to include in our IEPs social and emotional development pieces? See, this scares me. This is the kind of stuff that scares me. So in any event, we need to really think through some of these and advocate through our various organizations to make it such that there are other agencies that are equipped to do some of these things for students to hopefully keep them out of residential placements.
That's a lot to think about for sure. And that wraps up this overview of mental health issues. So let's move on now to part 3 of today's webinar, the next part of my presentation. Obviously, it's a closely related topic, the rules and practical implications for discipline of students with disabilities.
And this is going to be a major Q&D, quick and dirty version of discipline. I have a ultimate laundry list, but it's only 8 items on this laundry list of important tips that I think we need to remember as part of our review together. So I'm just going to go through each tip. Let's get started then with tip number 1. And this is a very general tip, but I am a firm believer in 2 things. Very clear procedures at the school district level with respect to discipline of students with disabilities and training. So tip number 1, maintain clear and compliant discipline procedures that are applicable to students with disabilities under both IDEA and 504, and adequately train all personnel on these procedures. So one of the things that I do a lot of when I'm working with school districts is to, as part of consulting with them, help them develop more practical discipline procedures that are user-friendly for school administrators who, for the most part, just like even the most experienced special educators, are mesmerized and very confused about the rules of discipline. They're incredibly complex, and they, frankly, just between us, don't make a lot of sense. When you really talk about the fact that the rules are entirely different as it relates to imposing traditional disciplinary sanctions for violations of the Student Code of Conduct, people are like, well, why is that? Why would a child who's receiving special ed services be disciplined any differently? Isn't that discrimination in and of itself to treat them differently? I mean, some really good questions that crop up. And so what I find is good school administrators who really want to do the right thing, which is my experience, most of them certainly, just want to know what they can do and make it as clear as possible that if this happens, then this is what happens. And so I like to focus on creating with school folks sort of checklists with respect to disciplinary scenarios and a guiding sort of checklist. Now, a lot of districts that I work with have a flow chart, but I'm just here to tell you that I'm not sure the school disciplinarian is going to pick up the flow chart when little Johnny brings a gun to school. And I can't necessarily tell you that the flow charts are easy to follow. They're pretty, they're kind of neat looking. I've even engaged in trying to come up with some myself, but I'm not sure they're very practical. And I think as user-friendly as we can be in developing our procedures, including some checklists, who to call, all of those kinds of things would be helpful, because what I find is school disciplinarians really just want to know what to do. Sometimes just knowing what to do is picking up the phone and calling the ESE office or special education office or what have you. And that's fine too in certain circumstances. But just making it as clear as we can rather than relying on convoluted lingo that we might use as part of a description in the Student Code of Conduct, having really clear procedures that will lead to better compliance because it's more helpful than confusing. And then after we've established something like that, then we engage in a lot of training and making sure that it's practical training that it's not just training where we show what the law says and the language, because it's very confusing. It has to be very practical. It has to include case analysis, case studies, saying in this situation, this is what should have happened, whatever it might be, so that they understand exactly what those rules are. I'm here to tell you even that is still confusing, but it can help lead to compliance rather than just stating things in your student code of conduct and expecting school disciplinarians to be able to follow that, or presenting confusing information that's just based on the actual language of the law, which isn't truly very helpful or practical when you're doing your training. So practical training is very, very important. So that's an overall tip, obviously. Getting more specific, let's look at tip number 2. Avoid making unilateral, as I call it, unilateral changes of placement through the use of suspension or other traditional disciplinary removals for violation of the student code of conduct. So right now it's important to remember that we are talking about removing students from the services that they are to receive to the degree that it constitutes what the law refers to as a change of placement. And one thing I always start off with when I am training disciplinarians is to make sure to focus on one controlling question. And that controlling question is, after the student with a disability has committed a violation of the student code of conduct, is the disciplinary sanction that I'm getting ready to impose, stop and ask, is that going to constitute a change of placement for this child? That is the controlling question that tells the disciplinarian where to go from there. Because if the answer to that is yes, it will constitute a change of placement if I impose this sanction that the student code of conduct indicates that I should. If they impose it and it's going to constitute a change of placement for the student, then a lot of stuff has to happen. Because when a student's placement is changed using traditional disciplinary sanctions, that triggers a number of procedural requirements under the law, and it constitutes a change of placement. It's also important to make sure that your school disciplinarians understand what change of placement is, because how can you answer that question if you don't know what a change of placement is? So under the law, clearly, a change of placement from a disciplinary perspective is any disciplinary removal for more than 10 school days consecutively, or in general for more than 10 school days cumulatively in a school year. And you should have that specifically written out as part of what constitutes a change of placement from a disciplinary perspective. So if a disciplinarian looks at the student code of conduct and it indicates that for that infraction that was just committed by that student with a disability, typically that is a 15-day suspension, that's going to constitute a change of placement. That means that triggers the procedural requirements under the IDEA. It's all about what constitutes a change of placement. Now, fundamental to that question is change of placement is defined by the services provided in that student's IEP. Placement is not necessarily location or site. It is the collection of services that are set out in that child's IEP, or for a 504 child, the services in a 504 plan. So anytime we are asking, is this particular potential disciplinary removal going to constitute a change of placement, we're looking at the document that shows us what services constitute placement, either the IEP or the 504 plan for the child. It's very clear, as I say under tip number 2, that prior to changing the placement, it can be done. But prior to doing so, if the answer is yes, then numerous things have to happen. First of all, a manifestation determination has to be made by the student's placement team, finding that the conduct for which the student has been disciplined or is going to be disciplined is not a manifestation of the student's disabilities. The IEP team then also must conduct a functional behavioral assessment and do a behavior intervention plan if they determine it's appropriate in a non-manifestation situation. And number 3, the team also has to determine what services the child is going to need in order to ensure that the child receives FAPE on day 11, 12, 13, 14, and so on of suspension. So those are the procedural things that are triggered if a disciplinary removal is going to constitute a change of placement for a student, which again is any disciplinary removal through traditional disciplinary sanctions, suspension, expulsion, other disciplinary removal for more than 10 school days consecutively, or more generally than 10 school days in a school year. Okay? So that's important that disciplinarians know that stop and ask that question first, because that answer to that question is going to guide where the disciplinarian goes from there. Tip number 3, keep in mind that when looking at what constitutes a change of placement, disciplinary action that might not be called officially a short-term suspension might still count toward the 10-day change of placement analysis. And the reason that I added this one as an important tip, because I see things that I call constructive eviction suspensions, where it's really not called a suspension, but it is the same thing. It is a disciplinary removal. And the U.S. Department of Education, as I indicate here, has also looked at those kinds of things. If a child's not receiving services in the IEP because of disciplinary action taken by the school, that's going to be a change of placement day. Things like home timeout, or a cool-off period, or even calling it something pleasant like happy home time with mom and dad. Whatever it's called, it's still going to probably count, more than likely count, as part of the change of placement analysis. So if those kinds of things are consecutively going on and there's a pattern, we might need to be concerned that we should be counting those as disciplinary removal days in considering what constitutes a change of placement. So the fact that we don't call it or officially document it as a short-term suspension, it still might be counted in the eyes of the U.S. Department of Education. You'll note there, too, a citation to the fact that the U.S. DOE has also noted that partial days, sending a student home early for disciplinary reasons, having the parent come pick the student up, those kinds of things could be considered partial days of exclusion that need to be counted toward that change of placement analysis. All right, let's move to tip number 4. Develop alternatives to suspension that don't constitute a change of placement. Remember, I indicated that change of placement does not necessarily mean change of site or location or classroom. Change of placement for the disciplinary discussion is changing the services or removing the child from services that are listed in the student's IEP. So it's the change of placement days that trigger all those procedural requirements that I talked about, the manifestation determination, the functional behavioral assessment, the BIP analysis, and the provision of FAPE during that change of placement removal time. Those are the procedural requirements that will be triggered. So are there alternatives to suspension that we can use that don't constitute change of placement days? Yes, there are, and school districts need to get creative with respect to what those might look like. One piece of advice that I do have is what we formerly called in-school suspension. Perhaps we should reconsider whether we call it something else. Because when we use the term suspension, that makes it, well, clearly perception in the mind of the parent, and perception is reality, that that is a suspension that's going to count. And parent attorneys will do the same thing with that. But moving the student to an alternative classroom setting, but continuing to provide all the services in the IEP, won't necessarily constitute a change of placement. And the U.S. DOE said it's their long-standing policy that in-school suspension, even if you call it in-school suspension, is not necessarily always going to count in that change of placement analysis. It depends on whether the student is continuing to receive the services that are listed in the student's IEP, in the in-school suspension setting, or alternate setting, as I prefer to call it, They're continuing to receive those services in the least restrictive environment, and they're continuing to participate in the general curriculum. And under those circumstances, the U.S. Department of Education has indicated that they would not necessarily treat that as change of placement. So we need to get real creative with respect to creating these alternatives to suspension scenarios that don't constitute a change of placement, that meet those requirements set out by the U.S. DOE, so we can clearly note that those are not change of placement days. I will say, just a little caveat here, if we find a student with a disability who's in the in-school suspension classroom all day, every day, then first of all, it's not working. Secondly, perhaps we have changed the placement. Maybe it's time to convene that IEP team and come up with something else and formally change the placement and not through the use of disciplinary sanctions. All right, let's look at the next one. Tip number 5. Be careful when considering whether transportation is a related service for a student with a disability, because it can be important in the area of discipline. So I always ask during workshops, so how many of you would view a suspension from the bus as a change of placement day? And it's funny because I get hands. Yeah, how many of you would? Suspension from the bus. Do you think, though, that there may be situations where it wouldn't count? Or does it always count? It depends. Very good. Everyone knows that's the legal answer. It depends. And that's what the U.S. DOE said in terms of bus suspensions. They said whether the suspension counts toward the change of placement analysis, the answer to that is very clear. It depends. And it does depend, doesn't it? Going back to that fundamental tip about thinking about whether it constitutes a change of placement, don't we need to look to the student's IEP to determine whether transportation is part of that child's placement? Is it a related service for that child with a disability? To throw transportation on every student's IEP can be dangerous, especially if there's really nothing special about it. It's not related to the child's disability. It is being provided because that child lives more than, let's say, 2 miles from the school. And every child in the district gets that. There's nothing special about it. However, if that child's disability requires us to specialize it in some way, either by adding staff to the bus or additional supervision or implementation of a behavior intervention plan on that bus, then it probably does become specialized in some form or fashion and part of the student's placement. And the U.S. DOE has said all of this, again, in their long-standing position that not every bus suspension is going to count toward the change of placement analysis. It depends on whether or not transportation has been identified as a related service by that child's IEP team. So let me ask you this based on that. Let's say a child has transportation, specialized transportation, it's specialized in some way. It's on the IEP as a related service. The bus driver decides to suspend the child for 5 days. And during that 5-day period, though, grandma decides, I'm taking him to school anyway. Okay? Do you think those 5 days are going to count if grandma takes the student to school? The answer is those 5 days would count, even though grandma brought him to school. Why is that? It's because those services are related services in the child's IEP, and they're changing the placement. Now grandma's implementing the IEP, technically, or grandma's having to do something when we're supposed to do it. So it kind of is counterintuitive, but that's what the U.S. DOE said, and they also reiterated that in Letter to Sarzinski. That's that OSEP Letter 2012. Now, if you as a school district want to count those days or don't want to count those days, I'm just telling you, U.S. DOE says you need to count them. Used to be the old rule. There was an old rule. The old rule was if the kid doesn't come to school, you count it. If they do come, you don't count it. That's, according to the U.S. Department of Education, that's not the rule. The rule focuses on change of placement and whether or not transportation is part of the child's placement because it is a related service. It's kind of a strange analysis, but it makes total sense when you're thinking about removal of services from the IEP via the use of disciplinary sanctions. Okay, so I use that example because it really kind of puts it into focus in terms of making sure that we're careful about articulating transportation as a related service on an IEP. Let's look at tip number 6. Keep appropriate and accurate data with respect to the use of suspension or other disciplinary removals from school for each student with a disability. If you don't do this, the Office for Civil Rights, the State Department of Education will be all over the school if we're not keeping appropriate data. Now, based on the data that already has been collected by the U.S. Department of Education, they are seeing significant disproportionality as it relates to discipline of students with disabilities. This is a huge issue that has been on the federal government's radar for quite some time, but recently OCR said that the data indicated from, I think, data collection in 2014, that students with disabilities were disciplined via out-of-school suspension 2 times more often than non-disabled students. Twice as often. My bet is it could be a little bit higher than that, just based on my experience, because in my experience, I have been caught in situations where the parents had better data than we did. In fact, this is something you don't want to have happen, that they have better data than you do in the midst of a due process hearing, where my records indicated the child had only been out for 5 days and the parents' information noted 21 days. And they had the letters to prove it and everything else. So we have to make sure that we are keeping good track of those days, okay? And making sure that when we have reached the change of placement point, that we trigger the procedural safeguards that need to occur if we're going to move further in the area of discipline. Now, some people like to argue with me, and I'll just mention this quickly, because they went to a school safety conference or something like that, and some resource officer that was presenting there said, don't let your special education director tell you that you only have 10 days of suspension in a school year for a child with a disability, because the law doesn't say that. I'm here to tell you, long story short, in practical terms, it kind of does say that. Because what it says is, yeah, you can go beyond the 10 in a school year as long as it doesn't constitute a pattern that's a change of placement. Well, so who wants to be the test case on that? As far as I can tell, I've found no volunteers with respect to whether 12 days in a school year is or is not a change of placement, or 15 days or 20 days or whatever it might be. So for the most part, because schools and states are monitored on the 10-day in terms of how that's what they're looking for. Any removal beyond 10 for a child with a disability raises the eyebrows. Whether it's a change of placement or not, it's a monitoring piece. So we should focus on, yeah, well, maybe there's some leeway there, but let's don't take that leeway. Let's go with the easy route, and that is making our data very clear that something is triggered when we start getting close to that 10 days. Because that's what it's all about, is making sure placement teams are involved in these decisions rather than unilaterally outside of the placement team process sending students home. So the data needs to be accurate and it needs to be monitored. It's essential in making sure that we don't have patterns from the perspective of the district that appear to be some policy, custom, or practice that is illegal and we're allowing it to go on. That's why the data is very, very important. And those are the kinds of things that parent attorneys look out for so that they can sue for money damages. So we need to be cautious that this is collected appropriately and red flag those situations that ring out to us. Perhaps we need to be monitoring this better. It's time to let the IEP team figure out things from here on out. Tip number 7. Remember that there are also special rules for students with disabilities in the area of discipline under Section 504, and those who just are considered disabled under 504. Interestingly enough, this, and a lot of times when I say this, school disciplinarians are very surprised by it. They didn't realize that, in essence, the Office for Civil Rights uses the exact same rules. Where they might acknowledge that 504 doesn't provide certain things that IDEA does, for the most part, they're going to apply the same procedures and the same requirements. The manifestation determination piece, which is probably the heart of the whole discipline procedural requirements and the one that causes the most angst out in the schools, that piece actually has its roots in Section 504. The reason a manifestation determination was required for the first time back in the 70s by the Office for Civil Rights was that we want to ensure that we're not taking away the right to education for a student with a disability who committed a violation of the Student Code of Conduct because of their disability. There was no intent there. It was something they couldn't help. And we take the education right away from them. We take the services away. And isn't that a form of discrimination against that student solely on the basis of disability? So if you've been around as long as I have, I remember in the 80s when OCR was saying you must do manifestation determinations. We were doing them well before the IDEA even mentioned manifestation determination. It didn't mention manifestation until 1997. So for years and years, we were doing manifestation determinations because the Office for Civil Rights required it as a part of anti-discrimination under 504. And then it made its way into the actual language of the IDEA. So OCR has been enforcing this under the auspices of 504 for many, many years. So it's really a 504 concept. It's not necessarily an IDEA concept. So for 504 only disabled students, we have to remember that the Office for Civil Rights is going to come in, and I can tell you because I've seen them do it, when they come in and they're monitoring, they're counting those days. And when they get to 10, oops, all the red bells and whistles go off, and they're looking to see what happened before day 11, 12, 13, and so on in the school year of suspension were used with a child under 504. Now, of course, most of the investigations they do are IDEA-covered kids, but their authority to do the investigation comes under 504. I have seen OCR enforce the same 10-day rule, the change of placement rule, plan or no plan. So that's where it gets kind of interesting because the 10 days thing, if we have a child with a disability under 504, and we talked about this earlier, let's say the child has a mental health issue, but we find the child has a disability because of that expansive definition, but the child really doesn't need anything. We find the child doesn't need a plan. We still have to make sure that if that child starts behaving in a way that violates the Student Code of Conduct and starts getting suspended, we've got an issue because that child is a disabled child, and we have to ensure that sending the child home for that behavior is not a manifestation. Hopefully we will decide it isn't, but plan or no plan, we do need to be concerned about that. I will tell you, in my experience when I'm training school disciplinarians, this one seems to be quite a surprise in terms of the 504 issue and making sure that we pretty much follow the same rules. Where the rules are a little different for a 504 only kid would be in the situation where if we find it's not a manifestation, under a pure 504 analysis, we can technically treat the child as we would a non-disabled student. And they are not entitled to continuing services as are IDEA children. So for IDEA kids, even if we find it's not a manifestation, we still have to determine what FAPE that child's going to get during that expulsion period. For a 504 child, there is no obligation to continue services. That's about the only major difference between 504 discipline and IDEA discipline. Lastly, tip number 8, where the school knows or clearly has reason to believe that the misconduct of a dangerous or severely disruptive student with a disability is a manifestation of that student's disability, strongly consider using the traditional change of placement process through the IEP team rather than going the suspension or expulsion route. and this is something that I'm a firm believer on, and a lot of people are surprised when I say this, but if you already know that that child with severe autism who hit that other student or hit that staff person or whatever they did, you're pretty clear that the answer to that manifestation question is going to be, yeah, it was. Then why are we going down that road? Why are we bothering to sit down and do that deliberation when we know the answer is going to be yes, which then the presumption is we cannot impose any further traditional disciplinary removals for that student? So instead, if we're really talking about a dangerous and disruptive child, shouldn't we be convening the IEP team to review the least restrictive environment analysis? To review that, to decide whether or not this placement is appropriate for this child. Maybe it isn't. Maybe this child, for that child's safety and the safety of others, needs to be moved to a more restrictive setting. And we propose a change of placement going that route rather than moving toward trying to suspend or expel that student. Again, I'm not saying that we do it with every child with a disability, because there may be some instances where we clearly suspect it's not a manifestation. We don't predetermine any of that, of course, but we clearly suspect it's not. We have no indicators that that was a manifestation. The clear-cut example I use, and there's not a lot of clear-cut examples, but the one I use just by way of making it more practical, is let's say you have a young lady who's learning disabled in math, and that's it. And she brings a marijuana cigarette to school, and she smokes it in the restroom with a friend. Well, nothing about that child's learning disability in math, nothing that we know about this child has anything to do with drug use. She's not engaged in that. That's not part of why we determined that she had a disability. So we're pretty convinced that it's not a manifestation. Then we would follow the traditional process, disciplinary process in that situation. Okay? But remember, she's still going to get services even if we expel her. Right? She's still going to get FAPE, but she could go to the alternative school and get that, or we could offer something as long as it ensures her ability to continue to progress in the general curriculum. Okay. But for those where we really know that, oh, why are we bothering with this? Because we already know that the answer is going to be yes. Then get off that yellow brick road of discipline. Don't go down that path. That's what triggers manifestation in the first place, is changing the placement via the use of suspension or expulsion or other traditional disciplinary removals. Bypass that. Don't even go in that direction. Tell the parent, we're not even contemplating suspension or expulsion, but what we do need to do is review this child's placement. And if it is concluded that we need to propose a change of placement, we follow our traditional change of placement process, which means we follow that meeting up with notice of a proposed change of placement. Remember, prior written notice, that's required. We provide that prior written notice of proposed change of placement. We advise the parents, again, of their procedural safeguards to remind them they have the right to challenge that proposed change of placement through mediation or due process hearing. Now, if they request a due process hearing, where does that leave us? Well, technically, we're going to be in what the law calls stay put. But if that child is severely dangerous or disruptive, then the school district might need to consult with its school attorney and decide we need to get a restraining order to temporarily move this child. And I'm telling you, I'm here to tell you that more school districts are starting to do that. That's really the way to do it, and that's what Honig versus Doe, the Supreme Court, said back a long time ago in 1988 with respect to dealing with our dangerous and disruptive students. So considering following the traditional IEP team change of placement process rather than the disciplinary removals that trigger all of these procedural requirements.
And that concludes the 8 tips related to discipline of students with disabilities to keep in mind, and concludes my presentation for today. I do see that we've had lots of questions coming in over the last hour, so I'm going to hand it back over to Stephanie, and we'll get to as many of those as we can with the remaining time. Stephanie, are you there?
I am. Thank you, Julie, for so much information on these important topics. You've given all of us some real-world knowledge to think about and digest, to say the least. Let's dive into some audience questions in the time remaining. The first question is, what is the impact of the Andrew F. decision on your understanding of a district's obligation to provide FAPE for students with behavioral, emotional, and mental health needs?
Well, Stephanie, I'm not surprised at all that people wanted to, or me even, to reference Andrew F. And as I was talking, I was trying to figure out where I could throw Andrew F. Or that Supreme Court decision that came out in March into the mix. So I'm glad there was a question there. It was kind of hard to incorporate it into the mix because it really was not a spot-on case as it relates to mental health issues or discipline. Those out there who are familiar with it know that it was the Supreme Court's opportunity for the first time since 1982 to provide schools with some clarification, as I call it, regarding the standard for the provision of free appropriate public education. So in general, my answer to the question as to how it impacts on students with behavioral, emotional, mental health needs, I would say if they are disabled under the IDEA, the new standard applies to them. So there's really nothing new about that or no change about that. And I will say I'll be looking at every single case that comes out of a federal court since Andrew F. to see how the clarified standard, or if the clarified standard makes any difference to what schools need to be doing, particularly with respect to students with behavioral or emotional mental health needs, which was Andrew F., who was severely, or is severely autistic, and the question was whether or not the school had afforded him free appropriate public education. But the real question before the Supreme Court was the standard that the 10th Circuit Court of Appeals used when finding that the school district had afforded Andrew free appropriate public education, using a standard that was articulated by the 10th Circuit as something merely more than de minimis educational benefit. And that was really what the case was all about, whether that was an appropriate standard. And the court generally ruled that merely more than de minimis is pretty much equal to nothing at all, and that was not an acceptable standard. So the new standard that we have, I guess we could say new, I would say clarified standard, but the clarified standard from a substantive perspective from Andrew F. that we're going to have to be looking at as we serve all students with behavioral and emotional mental health needs, asking whether the school's IEP is reasonably calculated to enable the child to make progress in light of the child's circumstances. And I think that the focus on the child's circumstance certainly can include the nature or severity of the student's disability, particularly if it is behavioral, emotional, or oriented toward mental health concerns. Those are going to, within those circumstances, and looking at educational progress and defining it, I think schools will be able to say in some cases, or in many cases, as the case may be, that, the focus of progress for this child is not necessarily academic progress. The focus needs to be on progress in the area of behavior, emotion, mental health, that kind of thing, because I've worked on numerous cases where the child's behaviors or emotional issues were so significant that the child really was not ready to learn. They didn't have behaviors in place to even be able to participate successfully in the general curriculum. And so I think we will see courts reminded that they need to assess a child's progress based on the individual child's circumstances, which is going to include, in my view, nature and severity of disability. And I've been monitoring the cases since Andrew F., particularly those that deal with emotionally disturbed or behaviorally disordered students. And One case that comes to mind recently decided after Andrew F., I think it's a Texas case, I can't remember the name off the top of my head, but the court even noted that when we look at progress and FAPE for this student, we're not looking at academics. For this severely emotionally disturbed student with lots of behavioral problems and mental health issues, the focus for assessing progress is different than with another child. One thing that I was hoping Andrew would actually tell us a little bit more about, and I talked about this earlier with respect to the residential placement and mental health concerns, I was hopeful that there might be some commentary with respect to, or from the Supreme Court with respect to what kinds of residential placement services schools would be required to provide as part of FAPE, and would that include any kind of mental health treatment. There are already, as I said earlier, there are already some residential placement cases that say that that is not the responsibility of schools, but I was hopeful that Andrew F. might even give us some Supreme Court insight, but it didn't. It just specifically talked about the clarified substantive standard for assessing FAPE. So that's a long answer, but the bottom line is it didn't really necessarily impact on us too much. But more to come.
Sometimes complicated issues take long answers.
Yeah.
One of the biggest takeaways I'm going to have from that for school teams is to really look at how the IEP is poised for that student to be successful. So thank you so much for that.
Sure.
Our second question is, what right does our district have in ensuring that parents follow through on our recommendations for getting their child the help they need?
Well, sadly, whenever someone asks me a question of that involves what rights a district has, I generally have to respond, not a lot. Anytime a question is posited that way, there's clearly no right per se, and there's no real way under IDEA particularly to enforce anything as it relates to a parent not following through on recommendations, particularly for mental health counseling or whatever it might be. And I know that some school districts are a bit wary about even recommending those kinds of services to meet a student's needs, because the argument could be that they're obligated then to pay for them or to provide them otherwise under IDEA. So, more remains to be seen. One of the biggest things that I've been hoping for is that we would see more lobbying efforts to increase mental health services and to put some, as I say, liability, for lack of a better term, some more emphasis on making those other agencies step to the plate and be as accountable as school districts are under IDEA, but the funding mechanisms aren't in place for that. I think there should be some focus on that. But when we can't bring them into the schools and we ask the parents then to follow through and they don't do that, then there's no right on the part of the district except maybe under state or local provisions regarding reporting abuse or neglect if it got to that point. Other than that, schools are required to serve the children as they find the children. And they may, if a parent doesn't follow up with trying to meet the suggested needs for mental health services or ultimately treatment, then an IEP team may need to convene then and discuss a more restrictive environment and proposal for change in placement to more restrictive environment. In the past couple of years, in seeing more school districts actually recommending residential placement, usually that can only happen, though, if the parent agrees to it. But I've had a couple of recent cases where the school district said, we don't believe we can educate this child outside of a residential facility. We can't segregate the educational needs from the mental health needs, and we're willing to fund residential. But I've had two recent cases where the parents said absolutely not. And so then what does a school do? And I think it may be then that if the parent won't allow for that and the student, let's say, is dangerous in the school environment, then the team may have to recommend the most restrictive setting, which could be a hospital home, well, not hospital, but homebound type placement, saying we offered residential, but the parent refused it, so this is our only option. And if the parent requests due process, then the due process hearing officer, administrative law judge, then helps us out in terms of where do we go from here. I just don't know what other alternatives are there right now.
Thank you, Julie. On a similar topic, the next question is, what is our child find obligation for students who have been hospitalized due to mental health issues? And is it an automatic special ed assessment?
No, not at all. And as I said when I was talking about the referral red flags, if folks are looking at those referral red flags, I never want anyone to take those out of context and say, oh, well, Julie Weatherly said that if a child is hospitalized, we automatically have to refer that child for an evaluation. I say it is a referral red flag, but it has to be analyzed in conjunction with any other things that are going on with the student and other data that's available to see if there are other referral red flags, because clearly hospitalization is not a reason necessarily. And particularly, I think the reason for the hospitalization, if it's just a broken leg, that's not going to trigger a child find responsibility. But if we're talking about hospitalization for mental health or chronic health issues, then maybe that would be considered a referral red flag. But again, it's all going to depend on other data and what the school knows or should know about the child to trigger the child find obligation.
There have been a lot of questions today, Julie, and it seems like just a lot of concern out in the field in general about when mental health issues are compounded by something else going on with the student as well, and how to differentiate those. So our next question is, what criteria should an IEP team consider in deciding FAPE when a mental health issue is clouded by substance abuse?
Oh boy, that's a tough one. Now, when I think substance abuse and treatment for substance abuse, I often get questions about the school district's responsibility for that. But I think the court cases that have dealt with that have been pretty clear that that kind of treatment is clearly not educational in nature and not the responsibility of the school district. But if a student is both grappling with mental health issues along with substance abuse, that could be very difficult for IEP teams to make good decisions about what evaluations are appropriate, if any, if a student is eligible. I'm not sure I really have a great response in terms of criteria that should be used. It's pretty tough to try to evaluate when a student also has a substance abuse problem, and it could be that an eligibility determination can't be made at that point in time. But I do think if a child is determined eligible, back to the Andrew F. question earlier on, using drugs is going to play into the circumstances of that student when assessing whether or not the child has been afforded FAPE. So if a student is receiving services that an IEP team has believed to be appropriate and the school district is providing them, making good faith reasonable efforts, but the child's substance abuse problems are getting in the way, I think that would be under Andrew F. part of the child's circumstances that would be considered in assessing progress and ultimately whether or not the students receive FAPE.
Thank you, Julie. You spoke a lot today about the relationship that should exist between the schools and the community and sort of a reciprocity of services. But our next question wants to address, what is the school district's legal responsibility for conducting mental health evaluations?
Well, this is back to that very, as I said earlier, clear legal answer of it depends. A lot of folks would like to say that, or school folks would like to just assume or say that the school district doesn't have any legal responsibility for conducting mental health evaluations. But as I mentioned earlier, and I think there was a question, I think I just in glancing over looked at a question that indicated or had a question about that Dear Colleague letter and resource guide that I mentioned that was issued by the Office for Civil Rights in July of 2016. And that can be Googled. Anybody can find that online. It's, you can Google just key terms, ADHD resource guide, Dear Colleague letter, Office for Civil Rights, and it will come up. And the reason I mentioned it here in response to this question is it talks about a school's responsibility to conduct an evaluation for ADHD, which, as I mentioned earlier, of course, ADHD is included in the DSM-5, so that would be a mental health evaluation technically. And OCR has concluded, and this is not really new news, this has been their position for a long, long time, but it's written clearly in this resource guide, that if a school team decides that it needs the information, the evaluative information, in order to make educational recommendations to proceed, for lack of a better word, with the educational program for a child with a disability or a certain condition, then the school is responsible for providing for that evaluation as a related service, either under IDEA or 504 for that matter, because evaluations for diagnostic and evaluative purposes are included as related services in the definition of related services under IDEA specifically, and then according to OCR. So the bottom line is, if a team, school team, decides that it needs that evaluation done in order to decide what the child needs educationally, then push come to shove, it is the school's responsibility. Now, oftentimes parents get those done and they bring them to the school's attention, and those certainly can be used. But OCR says that schools cannot force parents to go out and get those evaluations in this resource guide. And so it worries me when I'm sitting down with a school team and they're frustrated because the parent hasn't gone out and gotten that evaluation done, and they can't move on with the 504 determination or determining what the child needs under the IDEA, and they say to me, well, we're just waiting on the parent to get us that evaluation back. My response generally is, let's don't wait too long, because it ultimately is the school's responsibility, because you've made that educationally relevant and educationally necessary for this child. Therefore, it's the school district's responsibility to get it done.
Julie, thank you so much for referencing so many resources during your presentation today and during these questions. We've had a lot of appreciation for those in the comments, and always appreciation from school teams. So thank you for that.
Of course.
Our next question is, what is the typical legal process for change of placement due to disciplinary action? What actions can a district take if an offense is found to be a manifestation of a disability?
Okay, well, I would think that the tips that I went through gave a good overview of the typical legal process, I guess. Changes of placement due to disciplinary action, if a parent is upset with that, the typical legal process to challenge it is going to be through a due process hearing. And if they do that in a disciplinary context to challenge a disciplinary decision or disciplinary action that's taken, then the law calls for the convening of an expedited due process hearing. So it would be a much quicker process than your typical IDEA due process case. It's pretty complicated, and for school folks, I generally say you just need to let your special ed director and school attorney handle that typical legal process if there's a challenge. And then the second part of the question about what action a district can take if they find that a violation of the student code of conduct is a manifestation of the student's disability. Technically, we know that if they find that, then a change of placement through the disciplinary or use of the unilateral removals, as I mentioned earlier, the change of placement days, just can't happen. And so the presumption is if it's found to be a manifestation, the student will return to his or her current placement as defined under the IDEA or under the child's IEP, that program, as we discussed in terms of that being the placement for the student. So if it is a manifestation, not only is the presumption that the child will return to the current placement at the time that the child committed the offense, but also the law contemplates that the team must also conduct a functional behavioral assessment and develop a behavior intervention plan in situations where it is a manifestation.
We only have time for one or two more questions, Julie, so I'm going to try to leave you with some doozies here at the end. A lot of questions about a lot of questions about physically aggressive students. So our next one is, when a student has a tendency to lash out physically, what are the legal requirements to avoid restraint and to keep other students safe?
Well, first of all, I will say, another lawyerly response, it depends, and it does depend a lot on how a particular state sets forth certain requirements regarding the use generally of restraint and or seclusion. And, there was some discussion that began back in 2009 at a federal level where Congress was talking about legislating on the use of restraint in schools, but that was not successful. There were a couple things that passed the Senate and the House, but nothing ever came to fruition. But what we did see between 2009 and currently is that states put in place, most, if not all states, have something in place as it relates to either guidance or statutory requirements relative to the use of restraint in schools, so the states have kind of stepped to the plate. So in terms of specifics, and that's with respect to anything I've said today, with respect to some of the things, there may be state laws that have different requirements, even in the 10-day count or even what constitutes a change of placement, because I know in California, for instance, placement can also include site or location. So, when I generally present, I always like to remind people, check your state requirements. And this is a major state requirement in terms of the use of restraint and seclusion. But most states, I can't even remember a state that wouldn't allow for it. And the Office for Civil Rights in December 2016 issued another Dear Colleague letter to say, restraint is not prohibited, but it's pretty consistent. The language that's used is something to the effect that restraint is last resort and is used only when professionals believe that the student's behavior constitutes imminent danger to that child or to others. So, if restraint certainly can be used, but if it is required often, it may be time to sit down and revisit the student's IEP altogether and consider a change of placement to a more appropriate setting.
Super important information there, Julie. Thank you so much. We'll just do one last question. We'll do something that will hopefully leave teams with some actionable information here right at the end. Can you provide some examples of how we get creative to find alternatives to suspensions and expulsions?
Oh, boy, I wish I could wax on for 15 minutes with all these examples, but I'm just kidding. I wish there were a lot of them. I wish I had that many. But, as we discussed earlier, it isn't a change of placement according to the U.S. Department of Ed to move a child to a setting that continues the services on the IEP that allows the student to continue to participate in the general curriculum and allows the student to participate in the least restrictive environment, the same least restrictive environment that the student had in the IEP. And so those three things, when you're looking at getting creative, as you say, Stephanie, with that question, getting creative is making sure that you're not, quote, changing the placement, and that could include in-school suspension, although I would prefer that my clients not call it in-school suspension because suspension just kind of triggers someone to count it as a day regardless of what it actually is. And I find that in-school suspension these days and in-school suspension classrooms, the children are required to do work and they're not suspended from services at all. They're actually getting everything that they would have gotten. However, if a student is sitting in ISS all day, every day, then I have a problem with that as, you know, first of all, whether it's even an appropriate measure to use. It's not working. But other programs, I've had clients contract with outside agencies to provide space for alternative classrooms or things that don't constitute a change of placement but are used to continue the child's placement just in another classroom setting or different bricks and mortar. So getting creative with some alternative classes. I also worry about the use of the term alternative school anymore because a lot of people think the alternative school, when you use that term, that that's just where all the bad kids go, and that's clearly not the case these days. We have all kinds of different alternative programs that could implement a child's placement without, again, officially changing placement. So that's as much as I can do with my thoughts on creativity at this hour, at this point in time, and I hope that's helpful.
It was. It's all amazingly helpful. Thank you once again, Julie, for your amazing presentation and your answers to questions from our audience today. It's been a really great way to spend a hot summer day.
You're all very welcome.
Today's webinar with Julie Weatherly is the perfect segue to our upcoming 3-part 2017 fall series, Blueprints for Success, and an excellent way to start off another academic year. Be sure to make plans to attend the first webinar in the series on September 19th, when we'll hear from former NASP Executive Director, Dr. Howie Knopf. Howie will explain how you can build a stronger foundation for social, emotional, and behavioral success. And then on October 26th, we'll take a close look at enduring intervention designs for helping your students learn to read with Dr. Jeannie Wanzik. And be sure to register for the November 30th webinar as we wrap up the series with valuable insights from the world's chief architect and expert on differentiated instruction, Dr. Carol Tomlinson. We encourage your district team to watch and re-watch together and discuss how these strategies can be sustained and really make a difference for the students you serve. Watch your inboxes for registration details. If you are a clinician and working from home and having a more flexible schedule sounds appealing, know that we're always looking to expand our team of online SLPs, OTs, school psychologists, and social workers. Our clinicians are making a big impact on kids' lives through the wonders of interactive online technology. Check us out at presencelearning.com/join. And we're also thrilled to announce our new 30-day no-risk guarantee for customers who are new to Presence Learning. Within 30 days of executing your contract, we'll assign you a qualified SLP or OT, or your first month of services will be free. If you'd like to learn more, please email schools@presencelearning.com. We're excited to hear about the successes that districts are having with our exclusive online offering of the Woodcock-Johnson Cognitive and Achievement Test. And our partnership with Houghton Mifflin Harcourt is really creating options for schools to complete psychoeducational assessments. But you should really see for yourself how it works. Contact us at schools@presencelearning.com to arrange a demonstration, or you can watch a short video at plearn.co/WJ-demo. To receive a certificate of attendance for today's presentation, please stay online and complete a short self-assessment and feedback survey. Your suggestions and feedback are welcomed and appreciated. ASHA members, if you are seeking continuing education credit, we will submit your completion information to ASHA immediately, but it sometimes takes a few weeks for them to update your records. NASP and AOTA members, your certificate will contain the information you need to self-report for CPDs. Be sure to watch your email tomorrow for a link to the recording of today's webinar with Julie Weatherly and her comprehensive resource handout. Please share the link with your colleagues, and we invite you to tap into our massive Sped Ahead library of over 50 expert-delivered professional development programs. All of it is free, sponsored by Presence Learning. I want to thank you again for participating in our programs. Everyone at Presence Learning is passionate about being part of your blueprint for success, and we know how much you appreciate the advice from our professional development faculty. If you'd like to know more about Presence Learning services or to see how online speech therapy, occupational therapy, behavioral interventions, mental health services, or assessments work, just email us at schools@presencelearning.com or visit us at our website. It's great that you make room for Presence Learning's online professional development even during the summer break. Please let us know if there are topics or presenters you'd like us to feature for our future programs, and please enjoy the rest of your summers.